Now, let's understand what the Supreme Court can and cannot do. This becomes vital. This is part of what we forgot from 8th grade civics class. This is the Federalist paper. If the courts exercise will instead of judgment, the consequence would be the substitution of their pleasure for that of the legislature. Now, we have to appreciate what that term means. Judgment means this. A court can express a judgment as to what a law means through interpretation. That's what they did in the Obamacare case. State really means federal, or whatever it was, nonsense they came up with, where they interpreted, blue to be red and yellow to be black. I mean, they can do that. And arguably, that's what they tried to do by saying marriage has evolved into something new. But they can interpret a law. They can judge a law to be unconstitutional. They can say this law is unconstitutional. An elected official, if you enforce it, I'll throw you in jail for contempt. They can say that judge a law to be unconstitutional. I think I got that backwards. If they say a law is constitutional, they can mandate or mandamus the official to do it. You go down, you've passed your driver's test, you're over 18, you can see, and they say, I don't like you. You got a really nice car, I'm not going to issue a driver's license. The court would say that law is constitutional. Now, clerk, issue the license or we'll throw you in jail. If the law is unconstitutional, they can say don't enforce it, and if you do, we'll throw you in jail. But what a court cannot do is pass a law. That is called will. It's very clear what they meant. The legislative body has will. The Supreme Court does not. And I can't help but think that it's providential that probably the last president to really say this was our own native son, Andrew Jackson, in the case dealing with American Indians. And whether you like the case or not, he was right on a legal point where he said the decision of the Supreme Court fell stillborn. And they find they cannot coerce Georgia to yield to its mandate. Can the Supreme Court make us pass a law? No. They can interpret it, they can strike it down, but this is where the sovereign says, I will not pass a law. Now, in the handout that you've got, you'll see that Justice Scalia said this very clearly. I kept reading what he said in his last paragraph of his dissenting opinion. He said, quoting Federalist Paper 78, we're the most impotent branch. And he said, we depend upon the executive and the states for the efficacy of our judgments. And Scalia closed with, and every time we take from the people something that is rightly theirs to decide, we move ever closer to them reminding us of our impotence. And I kept thinking, what does he mean? What does he mean? What does he mean? What they mean is they depend upon us willy-nilly in our ignorance just going along and pretending that a law has been passed when one has not been passed and just executing the law for them. Hey, President, just do it. Governors, just do it. Pretend we passed the law. Legislature, pass the law. And if you don't, maybe the executives and the clerks will just do it anyway and pretend. Because we really can't make you pass the law.